All right. Good morning. Thank you, everyone, for joining us. My name is Ben Thompson. Kia ora. It's our first webinar for our New Zealand audience, and a pleasure to be involved. Congratulations to the Kiwis as well on winning the America's Cup. Great result. Today, I am joined by Claire Mansell and Aimee Elia. Thank you both for giving us your time and experience and expertise. This is a very timely update for the New Zealand employment laws, which are experiencing some change and fluctuation. So we're going to take you through a range of topics: the minimum wage increases, changes to leave entitlements, industry-specific fair pay agreements, and then a live Q&A with our solicitors here. Before we get into that, let me introduce myself properly and our panelists. So as mentioned, my name is Ben Thompson. I'm the co-founder and CEO of Employment Hero. I started my career also as an employment lawyer and spent best part of 20 years working with small and medium-sized employers in the Australian employment law regime, which is complex, and discovered that almost 100% of the businesses that I worked with found managing employment really difficult. There's so many things that happen when you become an employer that you were never aware would take place. You weren't educated to understand and control those things, everything from psychology to motivation and obviously employment law. It's just a constant daily issue is how to manage employment and how to become a great employer. And so that's where the idea for Employment Hero came from, was to basically digitize all the aspects of employment that we possibly could to give employers confidence and pride in the jobs that they create and provide to our society. 99% of businesses in New Zealand and Australia small and medium-sized businesses, and about 65–70% of all jobs in the economy are provided by those businesses. So we are talking to an incredibly important audience, and our job as Employment Hero is to make employment easier and more rewarding for everyone. So that's a bit about me and Employment Hero. Now, Claire Mansell is the Senior Associate at Martelli McKegg. She represents and advises both employers and employees on a range of employment issues. Claire has appeared in court at all levels, including the Employment Relations Authority, Employment Court, and the Supreme Court and the Court of Appeal. So thank you, Claire, for joining us. Good to see you again.
Sorry, just unmute. Thank you, Ben.
No worries. And Aimee is a solicitor in the litigation team and provides litigation services and advice on a range of commercial matters. Aimee has a particular focus on employment and construction law. Aimee works alongside Claire Mansell, providing advice to employers on a range of matters, including redundancies, personal grievances, dismissals, and compliance issues. And Aimee, thanks again for your time today.
Thanks, Ben.
All right, so as I mentioned, it's been quite a tumultuous year. People probably have taken their eye off the game a little bit while they've been dealing with COVID and all that's been going on over the last 12 months. And so we just thought it was an important moment to stop and observe what has been going on within New Zealand's employment law updates. Just to recap again, minimum wage changes, we'll be talking about those, changes to leave and entitlements, industry-specific fair pay agreements, and then a live Q&A. If you do have questions, please put them into the Q&A section at the bottom right of your screen, of the Zoom screen. If you throw them into the general chat, they're very hard to manage. So preferably put them into the Q&A. We'll be sending through a recording of today's session and other key resources. So if you don't entirely understand something first time around, you will get a follow-up. So with all of that behind us, let's jump into discussion point 1. Claire, could you please run us through the minimum wage changes?
Sure thing, Ben. So most New Zealanders will know in the middle of COVID, we also had an election, and after every election, there are employment law changes because it's a bit of a political football. And the biggest one, and the one that probably has the biggest impact on a lot of small to medium businesses, is the minimum wage increase, because that's a change, although it's pretty simple, it really does affect the bottom line for a lot of businesses. So we are now, as of 1 April 2021, minimum wage is $20 an hour. And I think it's the first time in my memory that we actually beat Australia in terms of our minimum wage. I think, Ben, you'll correct me, but it's about $19.80 something in Australia.
Yeah, $19.87 if I recall correctly.
So we're 13 ahead. You're probably playing with the exchange rate. You're still more bang for your buck in Australia. But so $20 is a standard rate. There are some exceptions to this, which I'm going to run through. The first one is the starting out rate, and there are a number of circumstances where you can pay the starting out rate, and the starting out rate is $16. So that's quite a big difference, a $4 difference, and it's for 16 and 17-year-olds who have not been employed with their current employer for more than 6 months. So if you hire a 16 or 17-year-old for the first 6 months of employment, you can pay them at $16 an hour. For 18 and 19-year-olds, there are you can pay them a starting out rate in a number of circumstances. Firstly, if they have come off a benefit and they haven't been employed by an employer before they went on that benefit. So the 18 and 19-year-old would have needed to be on a benefit for 6 months or longer and not been in employment before they went on that benefit. The other exception for 18 and 19-year-olds are those that are required to attend training with more than 40 credits per year, and that requirement is part of their employment agreement. So this is where you have apprentices who are coming in, you want to give them a chance, they maybe start a few courses, and then you can pay them $16 an hour. Now, these changes came about obviously because of there are a large number of what the government terms NEETs, not in education, employment or training. And it's basically an incentive for businesses to employ these young people and give them a chance, and without the, burden of having to pay $20 an hour. There are some exceptions. So even if you do have a 16 or 17-year-old or an 18 or 19-year-old that's come with benefit or is in training, you can't pay these wages if they are managing staff or if they are training staff. Now, I don't know why you would want a 16-year-old managing staff, but maybe you do. You have to pay them the full $20. So that's something to be really mindful if you are employing some of these younger people and you're wanting to pay them $16 an hour. You need to be very careful about what you're asking them to do. And if they're always on the computer and you ask them to train some of your other staff on computer things or something like that, then you need to be quite careful, because what you don't want is them to turn around and say, hey, actually, I want to be paid $20 an hour and I want to be back paid. There is another minimum wage that is lower, again at $16 an hour, and that's the training wage. This is for individuals who are 20 years and over, who are in a training program which is related to the occupation for which they are employed. Basically, it's for apprentices. So you need to be in training of worth more than 60 credits per year. It needs to relate to your role. They call it your occupation. So really it's going to be for apprentices, and again, you can pay them $16 an hour, but not if they're training or managing other staff. So you can't have somebody who is, a fourth-year apprentice managing a whole lot of staff, but still being paid $16 an hour. So, and again, just to give a bit of political context to that decision, probably a lot of you will know, there has been a lot of push from the current government, especially in the COVID response, pushing people into apprenticeships. And this is just another example of trying to make it easier on businesses or incentivizing businesses to train staff and to take on apprentices without having that financial burden. So those are the three main minimum wages. There are other exceptions, but they're pretty rare. Sometimes you can get an exception if you are hiring somebody with a disability. If you're in that camp, I would suggest that you get legal advice because it's pretty situation specific. If you don't pay minimum wage, then MB can prosecute. I think the penalty is about $20,000, and they do prosecute. Usually if you're not paying minimum wage, there might be other breaches of employment, such as not having an updated employment agreement, and they will go after every single breach. So you need to, if you do have staff on minimum wage and you haven't updated their pay, that needs to probably be a priority. And if you haven't been paying them, then backdate them to the 1st of April.
Claire, can I just jump in with my own question? And
yeah, sure.
Given I'm an outsider and naive, how much has the minimum wage increased by? Is the first question, and secondly, were there any such thing as junior rates? What we would call junior rates in Australia? Are they new or have they just been revised?
No, so I'll start with your first question, Ben. What was the rate before? 1890 was the previous minimum wage, and it's been steadily going up since 2017 when Labor first came into power, and it was signalled that it would go up progressively over the 3 to 4 year period to the $20 an hour. There was some suggestion that maybe they wouldn't do the final push to 20 because of COVID, but that doesn't, on PBR, they've obviously done it. In terms of junior rates, it's something that has been come and gone. It got abolished at one point and then has come back, but junior rates or training rates have certainly been around for a long time. There is I think most people are pretty comfortable with the fact that a 16-year-old is not going to need to be paid the same minimum wage as someone who is living on their own and, have all the bills and responsibilities that comes with that.
Yeah. So just before we move on to the next topic, there is a question, and just a reminder to everybody on the call, if you do have questions, please put them in the Q&A box. And as Claire mentioned, if you have specific questions that require legal advice, then our panelists can both help with any specific advice. Please reach out to them and we'll provide their details following the webinar. So Marie Patterson has asked a question. So all of the starting out rates of $16 can only be paid for 6 months. After that, it's normal. Is it the normal minimum wage of $20?
Yeah, that's so. The 6 months is for the starting out rate. The training rate carries on, and yes, once they come off that, then it's $20. So it's quite a jump. So you would be going, a $4 pay increase is quite a lot. So yeah, I guess it's a bit of an issue because you want to have a starting rate which is low enough to give businesses an incentive to hire these people. But then the flip side of that is that when they do come off it, it is a real big jump. So yeah, it is. Maybe it would have been better if there was some sort of intermediary, slide into that $20, but that would be more complex. So this is what we've got.
Great. Well, thanks, Claire. All right, Aimee, there have been a range of changes to the leave entitlements in New Zealand, including sick leave, bereavement leave, and a new holiday type leave. What do employers need to know?
Yeah, thanks, Ben. That's just a few of the changes that I think we are expecting to see roll out over the next 6 to 12 months. The Labor government actually established a Holidays Act task force, and that task force came back with 22 recommendations, all of which have been accepted. We've seen these begin to roll out with the bereavement leave in March, and it's going to continue. So at this stage, we have a lot of ideas of what is on the horizon. We don't know exactly how it's going to look. But for a general overview, the mission, so to speak, was two parts. One, to increase entitlements for employees, and two, to make the Act a bit more clear and easily able to be used by employers when they're doing these calculations, and make sure that they are able to easily and effectively meet the obligations under that. So I see the changes being in four parts. There's increased entitlements. There are the way that those entitlements will accrue for employees. For employers, the way that they can calculate those entitlements and pay them, and also obligations for employers to provide pay slips to make this really clear to their employees what they've accrued and what has been used. So really just to create transparency, clarity, and make it hopefully a simpler system. So the first thing, and which of course all employees are most excited about, is what are they going to get with these changes? The biggest thing is doubling of the sick leave entitlement. New Zealand, previously we have had 5 days paid sick leave, and that was comparatively low to other countries. There was a bit of discussion about, the need for COVID arising and the need for a lot of employees to have more leave available to them than they previously had. But also it was just to get us kind of on an equal par with other similar countries. So that is going to be increasing from 5 days to 10 days per year. And this is regardless of your work pattern. So if you are a part-time worker, you're still going to be able to take advantage of that.
So that, just to clarify that, this is a really weird situation where if you work 3 days a week, you still get 10 days. If you work 5 days a week, you get 10 days. So it really benefits part-time workers because it's calculated in days. So that's just a really weird anomaly, which existed under the old legislation, but they didn't fix, which, just something to bear in mind for employers.
If they're working part-time and therefore less than 8 hours per day, I presume they're getting a day's leave, but it would only be their ordinary hours per day, correct?
That's correct. But if you're working 8 hours a day, or say you want to condense your days, you want to work 3 10-hour days, then you're going to be, have a bit of a windfall.
Yeah.
And this will be relevant also when we come to talk about how we're going to calculate this leave, because it's going to be the greater amount of what you might have earned had you worked that day, or an average of either 13 or 52 weeks. But we'll talk about that a little bit more shortly.
Sorry to cut you off. Just Satwinder has asked if you could just repeat that, just that clarify or maybe I'll just clarify it for you. From 5 days now to 10 days, and it applies equally to full-time as well as part-time employees. So hopefully that clarified whoever didn't hear that. Thank you.
Correct.
So it doesn't matter how many days a week you work, you still get 10 days sick leave per year. You could work 1 day a week and still get 10 days per year.
Yeah. You were talking about how it's sort of bringing it to parity with similar countries. In Australia, we also have 10 days. That did increase from 5 days back in 2007. But it's also combined. So it's called personal leave rather than sick leave, and it can be used for both taking sick leave, but also to care for a family member or loved one. So somebody within a close proximity. Is that the same here, or is it only for personal leave?
Sick leave is for when you are sick or when somebody that you are responsible for or care for are sick. So you can use it if your child's sick, if your partner's sick, your parent's sick. It covers it. What it doesn't cover is those other types of leave, such as bereavement leave, which we'll talk about a little bit later. or annual leave, or domestic violence leave, which we have as well.
Yeah. And so just before we move on, there's a great question here from somebody who's anonymous, which is, does it still cap at 20 days or has this also increased?
No, the cap remains at 20.
Yeah.
Yeah.
Thank you.
And just also one other thing to note is that it's not actually enforced yet. We don't yet have this entitlement. It's in the second reading before Parliament, just waiting on the royal assent. But given the Labour government's total dominance in the last election, there's going to be no problem with getting that over the line. So I expect to see that probably in the next 3 months, I'd say. Once it receives the royal assent, it will come into force 2 months later.
And for those of you who are not completely au fait with the complexities of the Parliament system, royal assent basically just means the final rubber stamp from Parliament, and it's just a process that needs to go through. So we're expecting no issues there. It's just a matter of timing, and like Aimee said, it'll probably sooner rather than later.
Great, thank you.
Okay, so the next leave entitlement that I'm going to talk about is bereavement leave. Now we already have this available to people. We have 3 days available in the event of the death of a spouse, partner, parent-in-law or parent, and child. Now this has been extended to stillbirth and miscarriages. So if somebody, either themselves directly or their partner, experiences stillbirth or a miscarriage, they are entitled to 3 days bereavement leave. This is also available if you experience a bereavement out of when you are expecting to become a parent, either through surrogacy or through adoption. So that's just broadening the scope for which this leave is available. And that is in effect, that came into force on the 31st of March. So that's the very first change that we've seen to the Holidays Act task force recommendations.
And the interesting point with this one is that there's no proof required. So you can't request proof from your employee if they say, I've had a miscarriage and I would like to take this leave. And that may come as a bit of a surprise to some, but it's also the same for bereavement. So you can't ask an employee to prove that their family member has died in order to get bereavement leave. So something to bear in mind. I'm sure most people don't use bereavement leave for nefarious purposes, but certainly in my career I have come across employees who tend to abuse this because it's such a sensitive type of leave, and often employers are a little bit you don't want to be questioning somebody if they genuinely do have a family member that has passed on, but it can be a concern, and there may be employees who do abuse it. It's unfortunately the way that this legislation has been drafted, there's not a lot of room for employers to combat that without getting themselves in serious trouble. And if you do have somebody who you think is misusing this type of leave, I would strongly suggest that you give us a call and we can work out alternative ways to deal with that employee.
Great, thank you.
And just finally, just on that topic, it's available to men and women equally, so there's no gender distinction there. If there's no other questions, I'll move on to the last increased entitlement that we are going to discuss today. And that's been cause of some excitement, certainly amongst my friends and family, and that is the new Matariki holiday. So we have now got an extra public holiday available to everybody, and that is to celebrate the Māori New Year. The first one is going to be on the 24th of June next year. The date will change from year to year, depending on the stars, literally. But we expect it to be in between June and July, which is great because I'm not sure if you're aware, Ben, but our public holidays are really stacked towards the beginning of the year. So you get to this point, and I'm looking, I don't have a long slog until the next one in October. So really nice to be able to break that up with the midwinter holiday.
Yeah, we're the same. We have most of our holidays in the first third of the year, so
Yeah.
It would be nice to have that extra day. And just out of interest, if it does fall, if that holiday does fall on a weekend, will you get a public holiday on the Monday or Friday prior, or subsequently, or will it just land where it lands?
Monday-ized? I think it
I
is.
think it would be Monday-ized, or
Most public holidays which change, and if they do fall on a weekend like Anzac Day did this year, they're Monday-ized, which means that if you don't work on the weekend, you still get the benefit of that public holiday the following Monday.
Yeah. And I'm not sure if either of you will know off the top of your head, but how many public holidays do you get per annum?
it's 11?
Is it 12? Yeah.
Yeah, it'll be 12 next year.
Yeah. Okay. Similar. Great. Well, thank you for that. Anything else? I think there's a couple of clarifying questions here we might deal with on the fly. So one is there a cap for bereavement leave? I.e., if it's not taken, does it accrue?
No, it's each bereavement.
Yeah. And okay, so yeah, it's not that it doesn't even accrue. It's just if there is a genuine bereavement, then it's available.
Yeah, I mean, you can
and the
imagine there's a horrific situation where you lost a succession of family members and then you got to the last one and you couldn't take leave. I mean, that's quite awful.
Makes sense. And the last one is, it's kind of back to the original questions around part-time. So for a part-time person, if the person works for 4 hours a day for 3 days and he takes a leave day, will be considered 1 day leave irrespective of its duration of hours, correct?
Yes, so sick leave is calculated in days, and what a day will look like will depend on the employee and the employment agreement. So for your example of 3 days working 4 hours, a day would be 4 hours. They're not going to get 8 hours a day, but what they will get is 10 days, so 10 4-hour days that they can use. For those types of employees, sometimes it can be really handy if they're working really regular days to actually stipulate it in the employment agreement and say a day will be X amount, for the purposes of calculating sick leave, because it's not going to change. If you have employees that hours fluctuate, and this ties quite neatly into what Amy's going to talk about next, then there is, at the moment, some really complex rules around what constitutes a day. And anyone who has done payroll will know that this is just an absolute nightmare trying to work out, especially if you have shifts and they change, and it's just, it's a debacle. I think it's one of the worst acts we've probably got as the best act at the moment, and I wouldn't be alone in saying that. So what Amy's going to talk about next is trying to resolve these issues that come up when you have employees that don't work regular 9 to 5 days a week work, which when they drafted the Holidays Act, they must have thought that everybody worked like that. We obviously don't.
There's a bunch of questions here, and also a few people are having trouble hearing you. I'm not sure if I think when you change speaker, I think the microphone sort of tries to adjust, so there's just a bit of a delay when you change speaker. But if I can, so I'll quickly deal with some of the questions. So Satwinder asked, is the June holiday, or when will the June holiday start from? No, it's not next month, it's 2022. So Friday, the 24th of June, 2022 is the first June holiday. And I would try and pronounce it, although I know I'll butcher it. Would you do that again for me, please? Aimee? Thank you. It sounds easy to say, but it's much harder. Okay, and then what if a person works variable hours per day? What do we pay for the sick leave? Well, I think that was Michelle, and I think you're about to come to that, so we'll deal with that one. Another question was from Colleen. When does the new sick leave of 10 days take effect? That was after it gains 2 months after it gains royal assent. So the expectation is that it will gain royal assent, which is the formal approval from Parliament within the next month, and therefore it would take effect a few months after that. So probably around 3 months, Colleen. And then another question here, which may come into the next point, which is, how does the leave entitlement work for casual employees who work 40 hours a week? Do you want to deal with that one now, or is that something you'll get into?
I'll start by answering, I think you need to be really careful when you talk about casual employees working 40 hours a week, because casuals are really as and when needed. So, you know, you have somebody that you can call up to cover a shift if you're one short, or for a specific project and you know it's only going to be a couple of days. When you have employees starting to work 40 hours a week pretty regularly, if they end up on rosters, if they start turning up to work without you having to call them, they're probably not going to be casual employees anymore. They're probably going to be permanent employees, and that's irrespective of whether you have it written in an employment agreement. So that's just a thing to highlight, is that you need to be really, really careful with casual employees. Now, because casual employees are meant to be employed on an ad hoc basis, their leave entitlements are incorporated into their, at the moment, into their wage rate, which is 8%. So that's basically working out how much of a proportion their 4 weeks annual leave is, and then reducing it down and applying it to the hourly rate. So if you do have a genuine casual, then they won't be entitled to leave as such. They will just get 8% on top of their hourly rate.
And there's also going to be a requirement for employers to assess the position of these workers every 13 weeks to make sure that they are actually entitled and eligible for this pay-as-you-go leave. So rather than just, you know, kind of assume that it's you're actually going to turn your mind to it on a regular basis and make sure that you've got the right situation and arrangements in place for these employees.
What I've seen definitely in my practice is a lot of employees who are considered casual, they're paid their 8%, but they've been with the business for years and they work the same hours. You know, everybody sees them as part of the furniture, yet they're considered casuals, and that was seen as a problem that the task force had to address, and this is one of the ways that they've chosen to do it. So yeah, it means going forward, you should be mindful anyway, but going forward there'll be this requirement to really assess these employees and make sure that they are genuinely casual.
Is there such thing as a casual conversion clause in New Zealand? Here in Australia, if somebody has been casual for more than, did they just change it to 6 months? It used to be 12 months. Then if they're working regular rosters and hours, then after 12 months, they have the right to request that they are changed to a permanent position at any point from then onwards. Is that something that exists?
It's slightly different in New Zealand because, and this might sound a little bit technical, but the casual employees are not referred to in legislation, so they're not a creation of legislation. It's come about through case law. So the rules around casuals have all come to us through the court decisions. And what they say is that you really need to look at the position holistically. You need to see, you know, is there any expectation of ongoing work? That's the key term, expectation of ongoing work. And what they'll look at is duration of time, you know, how, is it regular work? If you're on a roster, you're pretty much, it's over, you're probably going to be permanent because you're expected to work. And what they see as casual is, you know, the person doing relief, you know, covering when someone's sick, coming in for a few days here or there. If you're working for a company for a long time, but it's on this ad hoc basis, then it's more likely to be a casual, and an employer would have to bring a to establish that. So problems tend to arise when casuals start getting left off the roster and their work comes to an end, and then they bring a personal grievance saying that they've been unjustifiably dismissed, usually because the employer thinks they're a casual, they haven't gone through any kind of process, and if you can establish that you're a casual, then, you know, you're looking at a pretty decent payout. So it can get really expensive for employers if they don't manage their casual workforce properly.
Great. Okay, well, thank you for that. Aimee, were you going to go on to another point?
Yeah, I think now's a good time to look at the calculation of leave entitlements and see how we assume that it may look in the future. We don't have the draft legislation or a bill yet to review, but what the task force has recommended is that rather than have these really complex calculations that even payroll professionals struggle with, the calculations are going to be based on the greater of one of three things, and that's going to be the ordinary daily pay, and that is what the person would have made had they worked that day, or an average of their earnings over the last 13 weeks, or an average of the earnings over the last 52 weeks. So that you're going to need to do all three calculations, and whichever is the greatest is going to be the rate of pay for that leave.
So anyone who's still using Excel spreadsheets to work out annual leave might need to invest because it's going to be difficult unless you have people that work the same hours every day and it's really easy. Most of the time, if you've got an employee that works an extra day here or there, you're going to have to do that calculation, and that's going to be time consuming unless you have proper software.
Just a quick plug for Employment Hero here. I should do it.
Leave it.
Thank you. Yeah, our payroll software does do those calculations, and we spent a lot of time building it and refining it for the New Zealand holiday calculations and leave entitlement calculations, because it is very unique around the planet. Our payroll system's used in the UK and Asia and Australia, but nothing quite compares to the calculations that are necessary for New Zealand. But it does work, and it's up to speed with all of those calculations if you want to find out more.
Yeah, and just another point on that, what Ben said is that some payroll companies who are based overseas who didn't get the New Zealand nuances, they're the ones that ended up costing their clients a lot of money and miscalculated annual leave. So yeah, it's really important. So yeah, if you're not signed up with Employment Hero payroll, then my strong legal advice is that you should be, because don't use an Excel spreadsheet.
Thank you, Claire.
That's
all right. Aimee, is there any more on that topic before we move on to fair pay agreements?
Yeah, sure. One of the other things that was always a struggle when these calculations were being made was, what is gross earnings? What income are you considering when you are making these calculations? Fortunately, we're going to get this clearly defined. Gross earnings are going to include all cash payments received other than any genuine reimbursement of expenses. So this is going to make it really clear and simple for those that are on commission, get commission, bonus rates, and all sorts of other variables. It's going to be really clear in our black and white legislation that it is any take-home pay other than a genuine reimbursement is going to be the figure that you plug in when you're doing that calculation. So it's really useful to have that clarification in the legislation.
For anyone who's paying employees bonuses, this will mean that you will be paying more for holiday pay for your employees. Previously, discretionary bonuses were excluded from this calculation, and sometimes people would have like up to half their pay be part of the discretionary bonus. So yeah, it will definitely affect those employees, particularly those that get paid sort of the higher amounts. They will be entitled to more because of this change.
Yeah. Just a little segue as well. We will be continuing our work with, so Employment Hero and Martelli McKegg have been working together to ensure that we have employment contracts and other policies and know-how in the Employment Hero platform. And we will, as the legislation passes Parliament and becomes effective across all of these areas, we will work together to update the content in Employment Hero, so you'll have access to the most relevant content. Aimee, any more before we move on?
Just one little bonus point, I suppose, for those that are returning to work from maternity leave, and under the current, like Claire, she's not quite there yet, but so there has been an override, which has meant that people returning from maternity leave, their calculations are based on only the average earnings over the past 52 weeks. So you can imagine somebody who's taken a full year, they're going to be looking at next to nothing. That is being changed, and people returning from maternity or paternity leave will now be receive the greater of those three calculations. So it may well be what they would have earned that day or over the past 13 weeks. So that's going to be really beneficial to people returning to the workplace from rental leave.
Yeah, but not for employers.
No.
It's you know, I'm just sitting here listening and realizing that, you know, all of this together is an extensive update to New Zealand's employment law and particularly leave, and that's before we get to the new fair pay agreements. So yeah, there'll be a lot more to follow, I'm sure. Yeah, so I might move on just in the interest of time to our third discussion point, and then there are a bank of questions already lined up. So so Claire, back to you again. There's been a fair bit of talk around the new fair pay agreements. Mm-hmm. What do we know so far, and what should employers be preparing for? Okay.
So I'll just quickly explain for those that don't know what a fair pay agreement is. It's basically an industry-wide agreement which sets minimum employment standards. So, for example, take the example of security guards. It will, for all security guards, set a minimum wage and any other minimum employment conditions, maybe overtime, maybe redundancy, things like that. And this was a promise which was made by Labor when they came in 2017. New Zealand First didn't like it, didn't go anywhere, but there was a report that was published by Jim Bolger, former Prime Minister. And what he has suggested is that fair pay agreements come into force. They are industry-wide. They differ from collective bargaining in the sense that there's going to be no strikes or lockouts, so there's no industrial action. The parties may be required to mediate, and if they can't decide, then go to the ERA. So what does this mean for smaller to medium employers? One, I don't think it's going to happen anytime soon. It's not, since Labor came in and end of 2020, there's been one comment by Minister Wood about wanting to pursue them, but it hasn't been on the agenda. There hasn't been much political talk. It's out for consultation. What I suspect you might see is sort of a watered down version, which won't have that much teeth and won't really be applicable. It will most likely only relate to the lower sort of paid industries. We talk about them being the vulnerable employees under the Employment Relations Act. So that's like your caregivers, your cleaners, catering, security guards. I don't think that we will see wider use of these fair pay agreements across multiple industries unless there's a real need. It's a little bit of a political tightrope to walk because it really cuts into what the unions are doing. So unions like E2 who work for some of these industries, it's almost like cutting out the collective bargaining side of things. So yeah, it'd be really interesting to see what happens. Nothing's on the agenda yet. It's just a wait and see. If you are an employer in this space, I would be keeping your ear out and seeing what's happening. But until we've seen the final version of what these fair pay agreements might look like and what kind of teeth they'll have, then it's all a bit of speculation. And my inclination is that I don't think they'll be as bad as what, as going back to the old days of arbitration. I think they'll be pretty industry specific, and I think they won't be as widespread as as they could be, because it will really be cutting into those unionised workforces.
Yeah. Well, that will definitely be one to keep an eye on, because certainly in Australia, where about 65% of employees are covered by what's called a modern award, that they increase the complexity of employment law by orders of magnitude compared to countries that have a single national minimum wage that isn't industry specific. Once you start to get those agreements applying to a business based on the type of roles within that business, just classifying the business within the right industry, and then having multiple different awards that can apply to an individual business. So, a retail business may have the retail award applying to the retail staff, but the clerical staff who work in head office are covered by a different award again, and then sales reps who might be on the road are covered by a different award again. And each award is 150 pages of very detailed obligations. So it gets very complex very quickly, and I hope that's something that is avoided.
Yeah, I get the sense that nobody really wants to do it, and it's sort of been put on the back burner, but we'll wait and see.
Great. All right, well, we might just now move into our Q&A. So if people have questions they haven't yet asked, please put them into the Q&A box, again at the bottom right of your Zoom screen. And while you're thinking of that, I'll start looking and go down from the top. So this first question, Claire and Aimee, is back to the minimum wage increase. It's from prior. The question is, if an organisation is living wage accredited, can they pay the minimum wage of $16, or do they have to pay the living wage rate?
Oh, so the living wage is, it's not a government mandated rate. It's basically an agreed rate that is seen to be enough to survive on if you are working to support your family. So you need to, I'm not, because it's not a legislative vehicle, it's not to do with the law, it's just a voluntary thing. I'm not completely up to date with the rules around that, whether they allow, accreditation allows for you to pay the starting rate. So you'll need to talk to the living wage, I forget what they're called, the organisation that runs that, to see whether they would allow their accreditation to continue.
Okay, great. I think we've probably dealt with this one. I'll ask it anyway, just so that we can provide more clarification. But Michelle has asked, what if a person works variable hours per day? What do we pay for the sick leave?
So your ordinary rate is what you would have paid if you worked on that day, and sometimes it's impossible to know, because like Michelle asked, well, they work variable days, variable hours each day. So that's when you start looking at the average under the new scheme, the average over 13 weeks or the average over 52 weeks, whichever is higher, that's the rate that you pay.
Great, thank you. Again, I think it's more for clarification. Colleen asked, she missed a section. When does the new sick leave of 10 days take effect? And again, that is after 2 months after Royal Assent. As for the minimum wage, are these all of these?
No, minimum wage is in now. Minimum wage is in 1st of April. Yeah.
Right. So these are all separate pieces of legislation, aren't they?
Yes.
Yep. Okay. So the new sick leave of 10 days takes effect 2 months after it gains Royal Assent. Probably in about 3 months' time, it will take effect. Okay. Can employees take a sick leave in hours, or can a policy be defined to clarify that it is deducted in full days? So someone who works 8 hours every day but takes 4 hours sick leave on a specific day, what will be the lawful deduction?
Well, there are actually changes to the legislation proposed to allow that sick leave in particular to be calculated in half days, quarter days, or full days, no less than a quarter. We're not going to go to an hour, but a quarter day will be provided for.
This was actually a topic of quite a bit of debate amongst the members of the working group. There has been a sense, particularly of those that work in the payroll system, that we should go to hourly, because most payroll systems work on an hourly, even though the legislation says weeks. And I guess in some sectors there was a great hope that we would move to hours, because it's just a lot easier from a calculation point of view. But the working group said no, and there has been other cases where where people have tried to convert days into hours, and the ERA has said no. Legislation says days, you got to do it in days.
Right,
So,
but there are provisions for quarter, half, and full day. Okay, great. Thank you. What is it if they work 6 hours one day and then 4 hours another? How do we determine a working day?
Again, it goes back to, if you can't determine the working day, then you look at the average over either the 13 weeks or the 52 weeks. And whichever is higher is the rate that you pay. So unless it's really obvious what a working day would be, because they work the same hours every day, then in most instances you're going to have to revert to doing those averages over either the previous 13 weeks or the previous 52 weeks.
Yep. Great. When do you think we will need to be prepared for the casual employee versus 13-week plus situation? I'm not sure what that is.
I think it's when is it coming in?
Yeah, so Nicola asked, when do you think we will need to be prepared for the casual employee versus a 13-week plus situation? I'm not quite sure what that means.
Yeah, I think you need to be prepared now, because although there'll be this requirement to review it, it doesn't change the state of the law at the moment, which is if you have employees who are on casual employment agreements, but in reality are treated like permanent employees, they could still be deemed to be a casual employee now. This new requirement, which we don't have the date yet for when it's being implemented, even if it will be, it doesn't change that. So if you have a casual workforce that you're worried about, I suggest that you give one of us a call and we can work through some solutions for you, because this requires, it's not changing the law per se, it's just making you take an extra step to consider it. That makes sense.
Yep. Annie asked, I missed the discretionary bonuses. I missed the discretionary bonus will be entitled to more. Can you give a brief on that? So I think what Aimee was mentioning about when calculating the ordinary rate of pay, you're now including discretionary bonuses. Everything other than a genuine reimbursement of expenses is included in calculating ordinary rates of pay. But that is still taking into account the previous 52 weeks or 13 weeks, depending on which calculation you're going to use, whichever provides the higher amount, correct?
That's correct. So to give an example, if you have somebody who gets $20,000 as their Christmas bonus, and they get paid that on the 15th of December, they usually work 8 hours a day. It's pretty standard, and their usual daily rate is, let's say, $200. When you go to pay them annual leave over the Christmas break, you're going to have to take into account that $20,000 bonus, because that will be part of the gross earnings over the previous 13 weeks or previous 52 weeks. So even though the ordinary pay is $200 a day, because of this bonus, the average over the previous 13 or 52 weeks is higher. They need to get paid at that higher rate.
Yep, understood. Okay, there's two questions here from prior. What happens if someone is on the 5 days sick leave currently, but the employment agreement runs over, say, for the next 3 months, and the legislation for 10 days comes into play, do we need to amend the employment agreement?
You will need to update. It's a change which will come into force irrespective of what's in the employment agreement. So on the date that it comes into force, all employees will be entitled to 10 days. At the next. Yeah.
Yeah. I always see it like a game of cards, you know, that the legislation trumps anything else. You can have an employment agreement, but if it doesn't align with the legislation, whether the legislation is just updated, then the legislation will trump what's in the agreement.
Which is why you need to keep updating your precedents for your employment agreements, because there are changes that happen, and you know, when we see them all the time, employment agreements which haven't been updated for 5-10 years, and they've got all this outdated, you know, entitlements in them, and they're, you know, not worth the paper they're written on because they don't reflect the reality, which is, you know, these new entitlements. So
yeah. And a similar one from prior, which is, will the increase in sick leave be backdated to the start of the employment agreement? I'm going to have a guess at the answer there, which is no. They start to accrue sick leave at the rate of 10 days per annum from the date the legislation takes effect.
Yeah.
Correct. And at the moment, these entitlements occur after 6 months of continuous employment or yearly thereafter. So these entitlements will occur on the anniversary. If you're a new employee, then you'll get the 10 days after 6 months. For existing employees, that will accrue after the next anniversary of your entitlements, bearing in mind that there will be changes made, and entitlements will be accrued on a prorated basis from the first day of employment. That's not in the current legislation, but that's another change on the horizon. So it will be prorated, it's not there yet.
Yeah. All right, there's one last question I'll answer. There's a few that we won't get to, just looking at the time. And I'll take the answer to this one. How many, because I've learned something here. So how many days sick leave will a person get if he works 3 days a week? He will still get 10 days a year. It doesn't matter how many hours you work per week, every employee will have entitlement to 10 days sick leave per annum. So look, that's been really informative for me as an outsider, learning about what are really substantive changes to the New Zealand employment laws. I think we all have to be prepared. Everyone on the call, I hope you feel part of a community, that Employment Hero is here to work with you and experts like Aimee and Claire to leave you feeling more confident about employment and managing all of these changes. So we will continue to be in touch and provide updates regularly. Our system will be updated with new employment agreements and everything that needs to change in relation to these changes in the laws. I want to thank our panelists. Claire, thank you for coming in. I know you've been on maternity leave and first day back, so nice to have you in the office. It must be nice.
Yeah.
And Aimee, thank you so much for giving us your time. I know that you are very busy, both of you, so really appreciate your participating in the event.
Thanks, Ben.
Thanks, Ben.
Thanks, everybody. You'll find an email with a recording of this. Hopefully you can hear it a little better, and also some other resources that we'll follow up with. But great to be working with New Zealand businesses. Thanks, everybody.